it does. Nevada has 4 basic kinds of alimony. There's temporary spousal support during the case, where a party is awarded maintenance or temporary payments while the case is ongoing. For post-divorce, there's permanent alimony, which means alimony that continues either during the joint lives of the parties or until one of the recipient remarries, usually. There's temporary alimony, which is the same, except it has some sort of fixed date or event where alimony is scheduled to terminate. And there's rehabilitative alimony, which is alimony intended to allow the recipient spouse to receive education or training for the purposes of the job or career or profession. It's extremely difficult to predict the outcome of any alimony case. They are subject to a host of individual circumstances and are highly variable based on the discretion of the judge. There's virtually no legislative guidance for how much alimony should be awarded, and although the Supreme Court has issued a number of alimony cases issuing guidelines, those also don't allow for specific predictions to be made. No. The Nevada Supreme Court has determined that simple fault or bad acts are not to be considered in whether to grant or deny alimony or how much alimony should be awarded unless they directly cause economic harm to the other party. And either husbands or wives can be ordered to pay or receive spousal support from the other. It is possible. The Nevada Supreme Court has determined that at least when an obligor is wealthy, old, and sick, the court should explicitly consider lump sum alimony as an alternative to regular alimony. It can be considered in other cases as well. The short answer is no. The Uniform Interstate Family Support Act, or UIFSA, has a peculiarity in it, where only the state that originally issued an alimony award can ever modify it. So even if everyone has left that original state, that's the only state that can modify the alimony. Alimony awards follow very different rules than child support awards, and it's necessary to consult with a specialist who understands the different rules. We know this subject very well. We actually created the analysis used by judges and lawyers to develop alimony analysis for use in court, and we teach the subject regularly to other lawyers. The Willick Law Group regularly litigates alimony cases on behalf of both obligors and recipients. Absolutely. Although we can't give legal advice over the phone because everybody's case is different, we can and will schedule a consultation appointment where we can go over your individual facts and circumstances and try to answer all of your questions. All you need to do is call us at the office at 702-438-4100.